The U.S. military has long done background investigations of persons having access to classified information. But even into the late 1950s, Congress hadn't expressly laid out grounds or procedures for denying or revoking a security clearance. The president had, by executive order, directed the secretaries of War and later Defense and the various service secretaries to assume control of their departments. But the president hadn't set out grounds or procedures for security clearance revocation, and the absence of congressional or presidential action led the Supreme Court to act in Greene versus McElroy. William Greene, the vice president of ERCO, a defense contractor, had worked for the company since his college graduation in 1937. He helped develop important technologies for the Navy during World War II. After the war, he was approved for security clearances 3 different times. But starting in 1951, Greene's security clearance was revoked, allegedly because he'd been a communist sympathizer. In 1953, the Secretary of the Navy reviewed Greene's case and again revoked his security clearance. ERCO fired Greene so it could continue its classified work for the Navy. And because of the revocation, Greene couldn't get another job as an aeronautical engineer. At a Security Review Board hearing, the government presented no witnesses and offered no evidence, claiming that its investigation, its documents, and the sources of its information about Greene were confidential. The board affirmed the secretary's revocation. Greene sued Secretary of Defense Neil McElroy, seeking an order that his clearance revocation was unlawful. The district court granted the secretary's motion for summary judgment, and the Court of Appeals affirmed. The United States Supreme Court granted cert.